Welcome everyone here. My name is Steve Zeltzer. I'm the Human Rights Chair of the Pacific and Media Workers Guild local here in San Francisco, local 39521. And we are having this presentation and presentations to discuss the effect of the TPP as far as journalist and internet and democratic rights. And that's why we're having this forum here tonight. And we think that this is an important question for working people and for journalists. And a lot of the secrecy in the agreement is one of the questions that are going to be raised tonight. And it was done in secret, and it has been released, so there's an opportunity to look carefully at it.
My name is Maira Sutton. I am Global Policy Analyst at the EFF. I've been working on the TPP for 4 years now for the EFF, and we've been concerned about agreements like the TPP for several years because of especially the provisions involving copyright protection, which is more like copyright restrictions, but also the implications of those rules and how they impact freedom of expression and privacy online. So in case there are people who don't know what the EFF is, a little bit of background. We are a 25-year-old digital rights organization. We started off as a public interest litigation organization where we take on cases for the public against the government or corporations or any sort of litigious entity that is trying to infringe on our civil liberties in the digital realm. And so I am on the international team, and we do international policy because we realize that it's not just domestic laws that impact our civil liberties on the internet and over our devices. It actually also comes from abroad and also from these international policy-making spaces. And unfortunately, a lot of that is from the United States itself. They use this process called policy laundering, where they pass rules that wouldn't pass domestically in a democratic, more transparent fora like Congress. And Congress is pretty untransparent and not very democratic in a lot of ways, but it is more democratic than international policy-making spaces, surprisingly. So we began to see these problematic copyright rules from the UN, from the World Intellectual Property Organization, and the World Trade Organization, and I'll talk more specifically about the policies themselves. So one of the main issues, I would say, that the issues in the TPP that would affect journalists and investigative journalists and whistleblowers are these provisions called trade secrets, or the criminalization of exposing trade secrets. And we had not seen these sort of rules in a trade agreement in this extreme form before. And it's extreme because the provisions say, I believe it's Article 18.78, that would make it a crime to quote-unquote misappropriate or disclose or access even corporate trade secrets through a quote-unquote computer system. And there are, of course, sort of flexibilities that would prevent huge ramifications for anybody that ever reveals anything about a corporation and their corporate wrongdoing, but they're very weak, and they don't actually protect against situations where investigative journalists might, for example, report on leaked documents that might be exposed by WikiLeaks, for instance, or documents that a anonymous whistleblower discloses about a company. So a recent example is the Sony leak that happened, I believe, 1.5 years ago, where it was probably the North Korean government hacked into Sony and released a ton of documents. And obviously that was a crime in itself, but these documents were floating around, and so of course reporters looked into what was going on within Sony, and they found out that, for example, that female actors were getting paid way less than male actors, that Sony, along with the Motion Picture Association of America, which is the Hollywood lobbying group, was working with state attorney generals to investigate Google, essentially to pressure them around making works available on their search engine. It was more of a political sabotage using state officials, and they were paying. In my opinion, they didn't call it bribes, but it was bribing state officials to investigate Google when this was really just about Hollywood and being afraid about piracy. So those were stories that were huge that came to light because of these documents, and what these trade secrets provisions, the criminalization of revealing trade secrets, could do is compel Congress to pass laws that would make it a crime for journalists to write about that sort of information that comes to light. So that's what we're very much afraid of, because there just really isn't any safeguard that says if it serves in the public interest that this information comes to light. There's nothing like that. So unlike copyright that has fair use, where there are these safety valves for freedom of speech, for patents, where patents must be published online, it's transparent what the patents are, no matter how ridiculous some patent cases are, that is transparent at least, but trade secrets are this sort of criminalization of trade secrets is ripe for abuse, especially when it's criminalized rather than just a civil matter. We already have trade secrets law in the United States. Companies can go after ex-employees who might steal a procedure and use that for a new company, or sell that. There's already a legal recourse. So we're very afraid that this new criminalization is very harmful and will be used to crack down on journalists. So that's one of the main things, but there are, of course, a huge range of other issues in the intellectual property chapter, which is one of 30 chapters in the TPP. For instance, the pure extension of copyright terms. We already have life plus 70 years in the United States, and that was passed in the late 90s. Under the Sonny Bono Copyright Act, which we believe was from direct funding and lobbying from Disney because they didn't want Mickey Mouse to fall into the public domain. And 6 of the 12 countries would have to extend their copyright by 20 years. So things that would have soon gone to the public domain would be extended under copyright, even if the author is completely gone, even if it's an orphan work, where the author is nowhere to be found or is long deceased. There's another 20 years of content that could not be archived or cannot be used for new works that would, maybe create new jobs, create all kinds of new interesting works. If you think about movies, if you think about books and stories and photographs, that again is under the restriction of copyright for another 20 years, regardless of whether the author cares about those works. So what does that mean for the United States? If we're putting these provisions in the TPP, this goes for actually all of these provisions. If we tie ourselves to the TPP, we can't reform our laws. I mean, it makes it very hard for us to be able to design laws that are designed for the public interest if we are putting these in a trade agreement, and if we, pass a law to maybe shorten copyright terms to, have a public interest provision in our trade secret laws to allow journalists to report on corporate wrongdoing, that countries can take us to the World Trade Organization Tribunal Court and say, you are undermining our trade agreement that we have signed with each other. So to go back to the more specific provisions, there are provisions around what's called digital locks or digital rights management, which initially came on the Sony CDs to prevent people from copying songs to their computers. It was an anti-piracy measure, but that completely backfired in Sony's face because it came with essentially malware that made computers slower, that was sending information from people's personal computer to Sony. It was very, very insecure for people to have this, but they thought that this would fight piracy, so they essentially thought it was okay. But they had to completely backtrack from that. But now what we're seeing is these kind of digital locks on everything from ebooks. So if you have like a Kindle and you buy an ebook and you want to maybe just look it on your computer, or you want to use a text-to-speech feature if you have a visual disability, if you have a video game that you have and you I guess it's impossible to play a video game if you have a visual disability, but if you wanted to add captions to things, if you have hard of hearing, things like that. So the changing of the format of digital content becomes criminal because it's locked under the software that is supposed to protect it from piracy, but it prevents you from doing all kinds of things that you might have been able to do with like physical things. So if you had a physical book, you could copy it, you can lend it to a friend, you could give it to a friend, you can sell it, you know, your yard sale, things like that. But when we have software, this sort of digital lock makes those things criminal because you can't unlock it. You can't sell the ebook, you know, to your friends because you can't, you know, you can't share the file on the internet. You can't, again, change the format if you have a disability. If you're a security researcher, you can't unlock a ebook or a phone or increasingly cars that have software on it because it has these locks. And it's essentially like a handcuff. You're buying this thing, but you're handcuffed from being able to actually do anything with the thing you've legitimately purchased. So these digital rights management or digital locks are very, very problematic when we see an increasing number of things come with software. And I said cars, but you know, hearing aids, heart monitors, heaters, refrigerators, security systems, and you know, there's a lot of with software comes more security vulnerabilities, and so it's a very dangerous thing when it's a crime to unlock the software. Talked about trade secrets, and another issue that's a number of organizations have talked about is investor-state rules. So it's a power that exists, unfortunately, in other trade agreements under the WTO and a lot of bilateral trade agreements where companies can sue governments over rules that undermine their profits. So the most recent example of this is the Keystone XL pipeline, where Obama decided after a long time to invalidate the license to allow TransCanada to build these huge pipes across the United States to transfer fracked oil across the country, and Obama invalidated it. And regardless of what you actually think about, you know, the Keystone XL project, it was a decision that Obama had decided to do, and now TransCanada, the Canadian case, is taking the U.S. government to court over that invalidation, and they're claiming billions of dollars in lost profits based upon that case. And we're concerned that this sort of that sort of very empowering provision for corporations to essentially trump national sovereignty to decide law that makes sense for the public interest or for whatever reason, for environmental reasons, for labor reasons, all kinds of things, can be trumped using this investor-state system. We're afraid that fair use, for instance, that allows us to use copyrighted content for criticism, for reporting, for all kinds of things, can be undermined because the TPP has even weaker, it's not even fair use, it's an exceptions and limitations. It's an exception to the rule that is explicitly listed one by one. Where fair use, we have a great system where it's flexible, where we get to decide, you know, if it's not the whole of the content, we can use it. If it's criticizing the content, we can use it. If it's not undermining the commercial interests of the original copyright holder. You know, these sorts of things have been weighed in court, and we have a really great system here, but we're afraid that this language in the TPP that says, you know, we have to consider these three-step tests around how it affects the author's commercial interests and all this, that investor state could be used by a foreign, you know, movie studio or publisher under these new TPP rules. So that's sort of skimming the surface.
Okay, well, thank you, Maira. And I was last year in Brazil at this Internet Governance Forum, IGF, and it's an annual United Nations event on governance of the Internet.
You're making me wait to listen to your dialogue.
So what was interesting is there are things going on all around the world as far as the effect of the internet and governance, and people in the United States are unaware of them, actually. That's what I discovered. So anyway, one of the issues is labor and worker rights and the effect of the internet and how it's controlled and how it can help or harm workers. And our next speaker is Richard Nee. He's a freelance journalist, and he's the vice president of the Guild and chair of the political legislative committee of our local. So welcome, Rick.
Coattailing a bit on what Maira has just told us, particularly with respect to ISDS or investor-state dispute settlement, it actually it nullifies, at least in that context, in that environment, nullifies our courts, because the ISDS calls for binding arbitration. And if whatever settlement, and whatever settlement is reached, the participating nations have absolutely no power to negate or go back and appeal. There's no appeal process, anything. It's basically three corporate lawyers deciding these things. But let me take you to some of the other aspects here, and particularly why the Pacific Media Workers Guild opposes the TPP. Maira mentioned Article 18.78, and that is really it in a nutshell. A little bit about the Guild and who we are. Journalists are a big component, if you will, of our membership. And of course, journalists have ethical considerations in terms of trying to do their job and be accurate and thorough and fair and objective. So we avoid taking public positions on most issues. We certainly avoid taking sides in candidate races. But we do make exception on issues whose outcomes affect our ability to do our jobs, especially issues dealing with freedom of the press and freedom of information. And freedom of the press, of course, is First Amendment. We oppose the secrecy of the TPP negotiations because we don't feel that our government should be doing things that decide on our well-being, if you will, behind closed doors. You know, we have a right to know what our government is doing and why. In the TPP itself, again, we oppose Article 18.78, which, as Maira already mentioned, would bar unauthorized disclosure of corporate trade secrets. Well, this means that a reporter, a news outlet, or a whistleblower who reveals some type of corporate malfeasance, say environmental pollution, a product defect or toxicity, or other kind of corrupt business practice, could face a lawsuit or even criminal prosecution and imprisonment. Now, this would be especially difficult for freelance writers and other individuals because they could ill afford to hire lawyers to defend them. Unlike a reporter for, say, the Chronicle or the New York Times, they would have, they're part of a company that has some financial resources to afford good legal backing. And what this would do is chill the willingness of others to bring evidence of corporate misdeeds to public attention. One of the arguments in court cases dealing with the First Amendment is the so-called chilling effect. If an action against a reporter, if there is an action against a reporter or a whistleblower, it has a chilling effect. Others will be less willing to come forward when they perceive a misdeed on the part of a corporation or on the part of government. Now, is 18.78 by itself a deal killer? We believe so. Having voted to give the president trade promotion or so-called fast-track authority, Congress may not revise the Trans-Pacific Partnership, but may only vote the entire package up or down once the president has submitted it. In the Guild's view, 18.78 would violate the Constitution, specifically the First Amendment, to the extent it should be a deal killer. And for those of you listening in or watching this video, we encourage you to urge your U.S. senators and House representatives to reject U.S. participation in the Trans-Pacific Partnership, as the Guild has done. Simply Googling the names of your senators and House representative will get you their contact information. And also, if you want to look at Article 18.78, it's the entire text of the TPP is available on the website of the U.S. Trade Representative. That's ustr.gov.
It's hard to take Trump for his word at all because he lies so much. So it's not clear whether he's completely against it, but I mean, the fact that he is criticizing it is very helpful. I think the fact that he has been raising the issue of secrecy and the fact that he, does paint it accurately as being a deal between these, corporate representatives in a back room, which I've seen him say, I think does paint the right narrative for a huge constituency in the United States. But I just can't say what he would do once he's in office because he's never really held public office. Whereas Hillary Clinton, I think, you are right to say that she has supported it. She was supportive of previous trade agreements like NAFTA, but as Secretary of State, she was, very pro-TPP with the White House. So even though she has come out against it, now it seems like she might flip-flop on this issue, but obviously EFF as a nonprofit, and we can't endorse or say for certain which one is going to be the greatest on the TPP. But I would say that Bernie Sanders has been the most consistent about his position about the TPP. So I would say that maybe he would be the most likely to not pursue its ratification in the United States, but it's very hard to say at this point. Would you like to answer?
Very briefly, I agree with Myra that it's really very difficult to tell what a president does once he or she is in office. Their promises are one thing, what they do is another. We've seen that time and again. Second thing, we all know that the corporations own both the Democratic and Republican parties. What a lot of people don't realize, or they forget, or they're not told, and this is a criticism of the corporate media, including PBS, is there is too little exposure given to third parties. I'm talking about parties on the right and the left. Okay, you've got the American Independent Party, the Reform Party, Constitution Party, Libertarian Party, Green Party, Peace and Freedom Party. They're all out there. Okay, they're very minor constituencies in terms of the overall voting population, but I suspect that that wouldn't be the case if they got fair exposure in the first place. We need to bring back the fairness doctrine. If you're talking about climate change, for instance, global warming, the corporations obviously have a vested interest in preventing the enactment and implementation of laws that would cut down or eliminate the carbon footprint and maybe the methane footprint. So I haven't personally seen language that would negate or hamper the peer review process, but given what we've heard, and given the tools, the legal tools that are going to be available to the corporate sector and to complaining nations, yeah, I'd say there is a very real danger that the peer review process could be compromised, and maybe we should have had somebody from the scientific community here on this panel.
We already have a corporatization of science. I mean, Larry Ellison, the Gates Foundation are involved in commercializing science. And we know, as a matter of fact, that even our universities, University of California, and the medical departments, you have professors who actually are in business with drug companies and are even in some cases testing their patients. It's been reported at Davis and other places. So the intermixing of corporations with control of our university system threatens really the credibility of our science. I mean, and what we're doing as far as medically and in other areas. So that's a great concern. The other point I wanted to make is another aspect of this agreement would allow corporations to take down websites without court order. So if you have a paper or document about Monsanto, for example, that they didn't like, they could say it threatened their interests and take it down apparently without even a court ruling. So that's really a threat to free speech. I mean, if a company can just say, we don't like your website. I know that they don't like a lot of websites on the internet, but this would give them the legal basis to just remove them. And I know as a matter of fact, that, companies have threatened, for example, IndieBay, that they want things down, that say something about what they're doing. And if they could use this TPP to take things down, it would lead to a lack of democratic rights, and it threatened our right to know, which is really critical.
All of the provisions of the TPP doesn't automatically become law. It's a step-by-step process. So essentially the next step of ratification for the United States is to figure out which aspects of U.S. law need to be changed to make it compliant with the TPP. And obviously this provision is in there, and we would say this is actually more restrictive than existing U.S. law because we only have civil remedies. Right now, it's not criminal. So if the TPP were to pass and our law were to become compliant with it, the fear is that Sony could, if this situation were to happen again, but a future Sony-like, plaintiff or complainant would file a report with law enforcement, essentially, and say that this outlet or this website is making these documents available. These are our trade secrets. That is a crime.
Sure, but wait a minute. That would take a separate law.
That would take a separate law.
Now, Congress can only vote yes or no on this. Let's assume that Congress says yes.
Mm-hmm.
But then Congress has the option to pass a law in compliance or not pass a law that's in compliance, right?
Right.
So that would have to happen first.
Well,
Passing TPP doesn't automatically have the force of law, right? It's saying that we agree with these provisions, but for the article we're talking about is 1878.
Well, we've passed many trade agreements in the past, and many of our laws have been amended to be compliant with those trade agreements, but there are many provisions that aren't still. And so it's just a matter of the other countries saying, hey, you're not complying with this trade agreement that we've signed together. So if the other countries really care about it, if we don't change our trade secrets law to be this restrictive, then it's sort of up to somebody to make noise about it. But what our fear is, because we know for a fact that these trade secrets provisions originated from lobbying from the U.S. Chamber of Commerce. It was like one of their top priorities, I am sure representing many, many corporations. They internally, after the TPP is ratified, could say, well, we have this provision in the TPP, we need to pass this new trade secrets law that would make it a crime. Digital locks provision, which actually sadly exists in U.S. law already. It's in the Digital Millennium Copyright Act. So in regards to your specific scenario, so Amazon has an app for the personal computer. They have a functionality within it to allow you to lend. But if you wanted to use a PDF viewer, if you wanted to use a different app, or if you wanted to, show it on your TV or make photocopies of it. You aren't able to print from the Amazon Kindle app, right? So if you wanted to print parts of it to maybe, if you're a teacher and you wanted to teach it in class, which is in some ways protected by fair use, then the act of changing the format, the digital format of the Kindle book is illegal. And it's already illegal.
But that's true now.
That's true now.
Amazon doesn't need the TPP to do that.
No. But what they want through the TPP is to lock us to these digital locks rules. So have countries that don't already have these rules to enact these rules. And in the future, eventually when we reform our copyright rules, it'll make it much harder to reform this law so they can retain this very restrictive provision.
Thank you.
So I wanted to go back to what you said about the websites taking down content, and that's actually already exists now too. If you go to YouTube, sometimes you'll see that a video has been taken down. So the reason why that happens increasingly, whereas in the past, somebody who owned the copyrighted work had to send a notice to YouTube and then take it down, and already that was abused because city governments, the city of Inglewood actually sent a copyright notice to YouTube because there was a guy, this local activist guy in Inglewood that was just taking the public domain, the publicly available videos of the city council meetings and just overlaying it with his criticism of the mayor. He was uploading these videos and Inglewood said, oh, we have copyright over these videos, you can't have these on YouTube. Even though, one, governments can't have copyright if it's all publicly funded because that's just the way the law works. But secondly, because we have these very swift mechanisms to take things down, that sort of speech gets silenced. This has happened with, political ads. If a political ad has some sort of song or some clip that somebody doesn't like, they'll send a notice and it'll automatically taken down. But the thing is, it's increasingly happening is essentially these algorithms are being used. YouTube is, because it would be so expensive for them to look at every single notice that they're getting, they're using robots. It's just like a scan. They're using code. They're encoding videos and audio. And it's sort of like a footprint. And then every time you upload something, it takes a really long time because they have to scan what you're uploading against this huge library of things that people have said is their copyrighted work. And then once it is not in that library, then you can upload it. But if it does have a clip of some song that Universal Studios label owns or Warner Brothers movie owns, you're a movie critic and you want to criticize a Spider-Man movie or something, and it automatically IDs positive for having that movie content, then it can preemptively tell you, oh, you can't upload this at all.
Universal doesn't have to protest.
Yeah, they don't even have to look for this stuff.
And that's the case.
They already have a private arrangement with YouTube to have this content scanned. So that's really dangerous when you think about, when you're in public spaces, maybe there's a song playing in the background and some newsworthy thing happens. Or you are a, Pokemon fan. This has happened actually. A Pokemon fan, you take a bunch of photos of your party and put it on the internet, then the company who owns Pokemon doesn't like it, so they'd send down, a notice to take it, a copyright notice to take it down. So it's really infringing on our speech when, all around us is culture that is copyrighted. And our ability to criticize it, our ability to share the things that are happening in our lives is getting silenced.
But different under TPP. This is happening.
It's already happening, yes.
Yeah, so what's the issue then?
Well, the issue is that it makes it harder for us to make our laws better. It's already happening. If we want to reform these laws in the future in the United States, it's even harder because all of this is existing in the TPP. If we wanted to have a law that said a judge had to look at every claim that something was copyrighted, that is not in the TPP. Chile has that system where every notice that somebody files has to be reviewed by a judge to say, oh yeah, this is actually correct. This person actually owns a copyright. we don't have that in the TPP, so if we wanted to do that, it would be, impossible under the TPP. For example, the initial copyright law in the very beginning was 14 years plus 14 years. And now we have life plus 70, automatic, regardless of whether you publish or not. So there's all kinds of works whose copyright status is uncertain. And if you're an artist, do you really care to have your copyrighted work secured for so long that, I guess you want your children to have, be able to sell that work, who knows? But there's so much work under this automatic life plus 70 copyright term, means that so much content that the author doesn't actually care about, that the author, is nowhere to be found. All this work is just sort of disintegrating. It's not being used. No one is able to access it or use it because of these restrictive terms. A reform could be, maybe 50 years copyright, and if you wanted an additional 20 years or 30 years, you have to make the effort to go register it, and you say, I want to have another 30 years on my copyright. Or requiring that because you made the effort to make the work, that you register the work, so that if people want to pay you to use a clip of it, if they want to understand the copyright status of that, that they could easily log into somewhere. They could likely do this, log in and see, this photo or this song or this article is copyrighted by this person. I want to be able to contact them and use it. There's nothing like that either. Under existing international law and in the United States, there is no ability to have a formality, a registration process for copyrighted works. So, and I know many artists that, wouldn't want it to be a crime for people once they purchase something to be able to shift the content to other devices. There's all kinds of things to make it much more restrained in a way that doesn't affect that balance between the public's rights to use things and to comment on things and the right and the legitimate interests of authors to secure their compensation for, or their livelihood from the effort that they've made to produce this thing.
Who did most of the lobbying?
Rick was going to comment on this.
Just briefly, one of the biggest targets of our complaints, one of the countries that we've had the biggest problems with on the copyright infringement side is China. And China is not part of the TPP. TPP is the U.S., Canada, Mexico, Peru, Chile, New Zealand, Australia, Brunei, Singapore, Malaysia, Vietnam, and Japan. And one of the reasons actually for the TPP is precisely to serve as a counterweight to China.
Who did most of the lobbying on the provision that you were just talking about there?
On
The takedown provision.
the takedown, all the Hollywood industries, so Universal, Sony, the Motion Picture Association is the umbrella organization, as well as the Recording Industry Association of America.
Okay, the music association.
So I went to 3 TPP negotiation rounds, and towards the beginning of the negotiations, well, I guess not towards the beginning of when I started to go, they had these presentations that people could give, stakeholders, including civil society organizations, union representatives, but then also corporate representatives. And my talk was right after Disney's. And Disney's talk was titled, Creativity Doesn't Exist Without Copyright. And I thought that was funny because Disney itself has used many stories that were in the public domain, including Cinderella, Snow White, Sleeping Beauty, which are stories that were in the public domain, and they have, which is great, they took advantage of culture that existed and they made this work, right? But the fact that they believe that, and were espousing that creativity does not exist without these, very extreme rights, and at least in its current form, was, I thought, very silly. But what was I gonna say? So one other thing I wanted to mention, just regarding the balance and the concern about researchers and scientific progress, was how in Colombia, they have a law that criminalizes copyright infringement for up to 8 years in prison and hundreds and thousands of dollars in fines, which was a result of its trade agreement, its bilateral trade agreement with the United States. And there was a case 2 years ago where a Colombian PhD student used Facebook. There are these groups on Facebook where it's, based upon research on a subject, and he studied amphibians in the Amazonian jungle. And he needed this specific paper. He knew the title of it. He knew the summary of it, but he couldn't get access to it because his library didn't have access to these very expensive, journals. So he went to this Facebook group and said, "Hey, I really need this paper. Can somebody send this to me?" And somebody sent it to him, right? He then turned around and used it, and then he made it available on, a Scribd. It's like a file sharing website, hosting site, just to give to other people in his community. And the master's thesis was written by this person who then filed a criminal complaint, and now Diego, who is the person who shared it, faces up to 8 years in prison in Colombia for sharing this paper. So I guess the question is, piracy is definitely one question, but should piracy based upon no financial motivation lead to someone going to prison? Or, the other question is, if someone should go to prison even if it made no commercial harm on the author, right? I don't think that this person who wrote this master's thesis about amphibians in the Amazonian jungle lost, hundreds of thousands of dollars worth of pesos because this person shared it on this document sharing website. So it's really a matter of balance, and what we're saying is that this balance is very, very much skewed against the public.
And let me just reiterate something here, and that is that if there are any disputes, they won't go to court. They won't be tried by a judge and a jury of one's peers. They will go before a 3-person international tribunal to binding arbitration, and the 3 people on the tribunal will be lawyers, corporate lawyers. In fact, some of those corporate lawyers will be representing industries or companies within industries that are in the specific disputes involved. So it will be skewed very much against the rest of us.
Yeah, that is already, the case as far as the Supreme Court. Ruling for corporations, ruling against public interest, and also jailing journalists or threatening journalists to release information. So we already have many examples, and not just around the world, but in the United States, of journalists facing prison for getting their stories out. And it's a growing threat. So I think that this issue is not just an abstract issue, it's a concrete issue for all journalists and people whistleblowers, people who want to get information out to protect the public, protect working people, to protect health and safety. So I think it's a very important issue. Thank you to our panel.